Good morning, counsel.
Matthew Campbell for the petitioner, Peter Hrycenko. May it please the court? The question in this case is about the writer's intent, Mr. Hrycenko. More specifically, the question is, did he write the letter with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere with a criminal proceeding of any type? The petitioner's position is there was no proceeding here.
Didn't you file a motion?
No.
Later.
That is,
Later.
if I could point out, especially the Commonwealth's brief number 19, they say he filed a motion. He never, the jury was never given a motion that he filed.
What was it that gave rise to his request that Judge Coffey recuse herself after this event?
According to the transcripts, there were two missives, two letters, two interactions. The first was the letter itself.
Yes.
The second was the motion to recuse. In fact, Judge Coffey...
Motion to recuse was not connected to any... Is that what you're saying?
Exactly.
Okay.
In fact...
Well, I'm sorry. Are you saying that at the trial of the case there was no evidence as to the February 2008 motion to revise and revoke, or that there was no motion to revise and revoke?
What I'm saying is there was no evidence presented to the jury of a revise and revoke. What was sent was a letter to recuse, and the Judge Coffey states, I had no motion in front of me. I'm quoting from the transcript, 254. And I had no motion in front of me. It's not as if this was attached to a motion to revise and revoke, a request asking me to do something. This was just sent, in my opinion. It was kind of random.
Regardless, though, wouldn't the policy be illogical? Because if there has to be a pending proceeding, because threats come often after the proceedings are over, after when the person is on trial and going to be sentenced by the judge, he's not about to threaten her then. He's hoping for either a not guilty or a lenient sentence, but it's only afterwards that he says, you know, now I'm angry at you, now I'm going to get you, whatever.
Right.
So the policy for the whole purpose of the statute would not make sense if this didn't apply to a proceeding, regardless of whether it's pending or not.
Well, the policy is to affect the administration of justice, whether or not he is doing this with the intent to affect the administration of justice.
Well,
And what we've got here is a
The
situation...
administration of justice is a general concept. It isn't in a specific case.
And the language also includes the word punish, suggesting, more suggestive of something that was done in the past. Punish for past behavior rather than harm you if you do something in the future.
That is true. However, I don't think that the facts of this case, the letter itself, in other words, rises to the level of punish. And it was never argued to the jury that this was intended to punish. What was argued to the jury was that the judge could have filed a revise and revoke. That was basically the Commonwealth's argument. They could have.
Defendant could have.
No.
Oh, sorry. I'm sorry.
I'm sorry. Who could have filed a motion to revise?
That the defendant could have.
In the letter here, you have the paragraph which talks about I know where you live and where your family lives, and then the same letter goes on, and this is within the period that a motion to revise or revoke could have been filed.
Right.
I want a stay of execution of my sentence. I want it to be commuted to time served. I mean, certainly this letter is about his criminal proceeding.
But was it, I guess the question is, was it to affect his criminal proceeding? If we are to take the position that the letter itself was a revise and revoke, that was something that was argued about, but was never argued to the jury, was specifically rejected by the trial judge, but more importantly, creates a big problem for the Commonwealth in that we're getting into petitioning activity that would be covered by the First Amendment.
well, But since the statute doesn't say pending, and as Justice Cordy just said, he clearly is asking for something to happen to his sentence, right?
That's correct.
He wants it reduced.
Yeah.
Correct.
So it's, why isn't it affecting a criminal proceeding?
What, I guess the answer to that is, what criminal proceeding is he affecting?
Well, clearly, he's intending to affect the criminal proceeding in which he has been sentenced, and in which, I mean, it's not an empty gesture. He does have the time to move to revise and revoke. So in that sense, the criminal proceeding is still going on.
Well, respectfully, if the potential of filing a revise and revoke is the standard about which when a criminal proceeding ends, then we open up a Pandora's box of, well, he can file a motion for a new trial for as long as he lives. And if the potential to file a motion is the standard of when the criminal proceeding is still open, then they'll be open forever.
But
Well,
that
but
Pandora's box is...
what's wrong? You don't even need, in my way of looking at it, you don't need a pending criminal proceeding. It doesn't say pending anywhere. All it says is criminal proceeding of any type. So of any type could mean one finished.
But what we're looking at is a situation where there is no proceeding.
But there was a proceeding.
There was,
Right.
but under the case law mentioned in my brief, that was over.
Okay.
The sentence was given. The sentence pursuant to Mosher and hinted at in Kathy C., the sentence is the final stopping point of that particular criminal proceeding. If another proceeding was started by the filing of a revise and revoke, then I would submit that you would absolutely have a situation where you could intend to affect that proceeding. But there was no motion here.
Okay,
There was
so-
none filed whatsoever.
so
So
you're-
what we're looking at is a situation where the possibility, and that's what the Commonwealth argued in its closing, the possibility alone is enough.
Well, if you're right, then there's a window of time where a person could conceivably threaten a judge and there'd be no repercussions.
Well,
That's the time period between the sentence and the filing of the motion. That
There is-
couldn't be, could it?
No. And what the Commonwealth would have to do at that point is tell a jury, this is the letter, and here's the motion that the letter was intended to affect. That did not happen in this case.
Now, Mosher, the case you mentioned, Mosher, was that dealing with this statute?
No.
No, it was dealing with when there's a disposition. But it wasn't dealing with this statute. Kathy C. was apparently, or the prior version of this statute.
Yes.
But that's an appeals court case. Is there any case from our court that says, that's interpreting this statute as meaning the proceeding must be ongoing?
No.
So if you're right, if somebody writes a motion to a judge after the sentence and says, "Dear Judge, I've not yet filed my motion to revise and revoke or my motion for new trial, but I intend to, and if you were to deny that motion, I will kill you and your family."
That brings up an interesting issue. Is that petitioning activity?
It's within the First Amendment to be threatening to kill somebody in...
No, but it is a true threat.
Well,
Well,
that's a
that's a
separate
different
issue.
question.
That's a separate issue as to whether what this was constitutes a threat. But you're saying that even if it were to reasonably constitute a threat, that it can't be deemed so because there was no proceeding.
Well, I think that there would be evidence that the Commonwealth could produce at trial that he says here in his letter that he is going to kill her unless she changes his sentence. And I think that would be, and actually the letter in your hypothetical foretells a filing of a motion. So the Commonwealth could certainly argue to the jury. He was going to file a motion.
Okay, but doesn't your letter, your client's letter, portend a motion? He asked for a stay of execution and to be commuted to time served.
It portends it. Quite honestly, the letter is rambling, 9 pages.
Okay, well, that, the
I'm not quite
question
sure.
of whether reasonably may be understood to be a threat is a separate issue.
Yes.
But assuming it is, and I don't ask you to concede that it is, but assuming it is, why is it not analogous to the letter that I just described, except as a matter of degree? There is no pending motion, but there could be. It seems that what you'd be saying is that that would not be sanctionable.
I guess I understand your analogy. What I'm saying is that under the particular circumstances as presented to the jury here, that it was not sanctionable.
Okay. Because of the ambiguity of the letter or because of the timing of the letter? I think there are two separate issues here.
Well, obviously I'm arguing both, but the timing, not so much the timing, but rather the evidence presented at trial.
You're arguing that the evidence based on the specific theory, that the specific theory required the presentation of evidence that there was? Is that
Exactly.
how you're saying that's how it was presented? There was a motion, and here,
And this was
And
the
then they
criminal
didn't-
proceeding that he
and they
intended
forgot to put in that
effect.
evidence. Essentially, that's what you're arguing.
Correct.
They forgot or there wasn't?
I'm sorry?
They forgot to put in the evidence about a proceeding or there wasn't any evidence about a proceeding?
I think you'd have to ask the Commonwealth that.
Well, no, I'm asking you because, he either filed a motion to revise and revoke or he didn't. I mean, on your theory that he had to.
My belief is that there was one filed, but one was never presented to the jury.
I understand that. And that's what you say had to have been presented.
Yes, a specific document saying that this is the proceeding that he intended to effect.
Okay, but of course the problem you have is that if going back to my hypothetical, if he's arrested immediately, he wouldn't have had, I guess he could write his motion, then he'd have to do his motion to revise and revoke after the charge of intimidation was lodged against him.
Well, in this particular case, he was writing from jail.
And had the charges already of intimidation been lodged against him?
No.
No.
Okay,
He
so
was serving a
in my
sentence.
example, in my hypothetical, the individual is immediately arrested based on that letter. Charges of intimidation are immediately lodged against him. You would say, no, you can't lodge those charges against him until he actually moves to revise and revoke.
Well, no, there would be a separate criminal proceeding at that point.
Right, but they would be based on the statute, violation of 13B for the threats, but you say, but there can't be a violation of 13B because there's no such violation until he actually files the motion to revise and revoke or the motion for new trial, and he hasn't. And
Well,
therefore-
I'm not being as formulistic as that. What I'm saying is that the evidence has to show that he intended to interfere with the proceeding. And that the evidence, I didn't say that in any hypothetical that the Commonwealth cannot prove their case. I'm saying that in this particular case,
They didn't.
they did.
Okay, now I guess turning to the question of ambiguity, I mean, he begins the letter pointing out that he knows where she lives and he sends it to her home as opposed to the court. Is there not an inference that could be made from that?
Well, if taken in a vacuum, yeah, you could create an inference. But reading the whole letter, if you look at the closing of where he apologizes for sending it home, he explains why he sent it to her home.
I'm sorry, he explained the reason was?
To get away from the hectic courthouse during the Christmas season. It's not a
And you consider that, as a matter of law, that's sufficiently credible that it should be viewed as?
No, what I'm saying is overall, the letter, read as a whole, is insufficient to be interpreted as a threat.
Mr. Campbell, you're going to have to wrap it up. Your time's up.
Okay. Basically, written documents have a tendency to be interpreted in a multitude of ways. As soon as they get on paper, people can pick an attack at it. Some are reasonable interpretations, but many are not. The Commonwealth's interpretation of these letters is not a begging letter, which, if you look at it, that's what this letter is. He's begging, please, I'm not happy, here's my life. The Commonwealth twists a lot of what he has to say, saying that his description of his hard life are things that he's going to bring on Judge Coffey. That's not true. He even says that the list of references he gives, the Commonwealth argues those may be unwitting participants in some sort of crime. He argues the defendant writes about his bad record, he explains his bad record, and they argue he's using it to intimidate. I would just ask the justices to please read the entire letter in context and see what's reasonable here.
Thank you, sir.
Thank you.
May it please the Court, Joseph Didkoff for the Commonwealth. Let me just start by clarifying the timeline. It was December 20th, 2007 that the defendant was sentenced. He wrote the letter, at least it's dated 3 days later. It arrived, it was postmarked on the 26th, 6 days after sentencing, and the 27th it was received. On that day, or maybe the day after, state troopers went and interviewed, or attempted to interview, the defendant. So by that time, by 8 days after sentencing, he was aware, and the charges were brought, not the indictment, but the criminal complaint was brought well before the 60 days passed. Whether what's in page 24 of the record appendix is itself a revise and revoke motion, it certainly isn't, doesn't have an affidavit, so by itself it couldn't be granted, but of course he's pro se. The fact that having been approached by the police, he may have changed his mind about filing a motion for stay or revise or revoke doesn't change the question here, which is, did he have the intent to interfere with the criminal proceeding? If he intended, as he says he wants, to ask for a stay, to ask for a revise or revoke, or intended her to use her sua sponte powers to grant that and wanted to...
You said that the letter itself is a motion to revise and revoke. Did the judge, as a matter of law, instruct the jury to that effect?
The judge instructed the jury about the law, about having the judge having 60 days, could do it on her own motion or otherwise, did not instruct her that the letter itself was or was not a Rule 29 motion.
Okay, was the jury asked to decide as a question of fact if the letter was a motion to revise and revoke?
Not as such. I mean, the main argument here was that he intended her to change his sentence. I don't think it wasn't really that specific. You have the closing arguments.
Mr. Ditkoff, let me ask you this. Let's assume this isn't done shortly after the sentencing. It's 6 months after. So this 60-day period in which the sentence can be revised and revoked ordinarily has passed, and he just sends this same letter. Same situation, same crime.
Yes, Your Honor. She can still grant a stay of execution. And if he has the specific intent that she do something with the specific intent that he's either going to file a motion or a motion is going to be filed, it all goes to his intent. You could file a motion for new trial.
So, in fact, as long as the criminal sanction remains in effect, one can file a motion for new trial, and indeed even after.
I don't even think it's that.
Almost always file a motion for new trial. So this is a never-ending criminal proceeding.
It's not a question of the criminal proceeding being never-ending, but if at any point a defendant has the intention to
interfere with a criminal proceeding.
A criminal proceeding that he foresees, that he intends to happen, and he has the intent to interfere with it, then he can violate the crime. There is no point in which the legislature wanted you to be able to interfere. If 30 years afterwards you have immigration consequences and you're going to file a new trial motion, and before you do it, you find the lawyer who represented you and you tell him, I'm going to kill you if you don't file an affidavit saying you didn't instruct me on my Padilla rights.
So if this was just a threatening letter, saying I'm very angry, I know where you live, et cetera, it doesn't mention I want you to stay my sentence, I want you to commute my sentence, makes no reference to a future criminal proceeding, just angry at what the judge has done. I take it your view is that would not be covered here, or would it be covered under a different provision of the statute?
He might say it's under punish.
Punish, maybe, punish?
It may well be under punish. I think the gravamen of the punish harm theory, though, is you have to remember this statute, its primary focus was gang violence and intimidation. And when you have repeat players in the criminal justice system, they might well harm a witness to send messages to the next trial and to interfere with the next trial. Mr. Hrycenko is a repeat player, but he's not of that level. I don't know if we could have proved I don't think we could have proved the specific intent as to Mr. Hrycenko under that scenario, but it can be done in principle. Okay. Depending on.
Sorry, please finish your sentence.
Please, Your Honor.
This isn't the theory under which the case was presented, but I can't help noting that the way you lay out the statute that was in effect at the time, Section 13B, and actually presently as well, you put in a break where there is no break in the actual statute. And everybody argues that the provision, the specific intent provision that is actually within subsection 5 of the statute, actually also modifies every other subsection of 13B1C. It is, however, that is one construction, and since the break isn't there, and I see the argument for making that break there, but it isn't there. When the provision regarding judge, juror, grand juror was included, it would be a standalone, would it not? It does just say whoever directly, willfully threatens, attempts a judge, juror, grand juror, suggesting a person who is engaged in a role, not just someone who happens to be standing in the supermarket, me shopping, happens to be a judge and I'm threatened, but as in that role could be a crime.
I think that's true, Your Honor. It's not the way it was instructed in this case, so I don't think it does me any good for this case.
But you did put that break in because that's the way you view the construction of the statute as requiring that break that it modifies everything.
That is definitely the way we asked the judge to instruct in this case, and that we proceeded in this case. With the new statute, it's even more questionable whether that break belongs there, right, because of the way the proceedings have had. But also in our view,
all the cases interpret it that way also.
That's right, Your Honor. In our view, that construction solves any constitutional problem.
I understand.
Because if you have the intent to interfere with the criminal proceeding, it's constitutional under the First Amendment to ban it. There's almost nothing you can do with that intent. Even picketing, the U.S. Supreme Court has said. I know we're not here under the First Amendment issue, but I think that is what preserves this statute from any constitutional attack. So that's certainly the way we proceeded, asked that it be instructed and be done. I understand one could see it the other way, but that brings up issues that we certainly didn't want under the First Amendment in this case.
With respect to the second issue here, that is this really, does the contents, put aside the proceeding issue, the judge instructed on threat, intimidation, and harassment. I mean, all three of them, right?
Yes, and harm and punish as well.
Okay, but
yes, those were the ones that we were concentrating on, Your Honor.
So, in theory, since there was no special jury slip saying which one of these do you find, obviously there has to be enough evidence for all three.
I don't agree with that, Your Honor. I don't think these are different in the Plunkett sense, just like the Brian Smith case Your Honor's decided this term, where you had the two versions of armed home invasion, whether you had to have knowledge of occupation at the time of entry or knowledge of occupation at the time of remaining. This court said those are not Plunkett-type separate issues. There doesn't have to be sufficient evidence of both, and I think these are much less separate issues in that sense. Plunkett sort of separate sufficient evidence is reserved for things that are very different, like the 3 theories of first-degree murder. The case law is inconsistent on assault. Generally hasn't been the 2 theories. I mean, I could go on for some time on this.
Well, okay.
Frankly, Your Honor, I don't want to bore Your Honor.
All right. Put that aside. I really wanted to focus on whether you think, if you take the definitions that she gave of each of these, in your brief, you talk about harassment and I think threat. I forget. It's 2 of the 3 now.
Intimidation, I think, is what I focused on.
So do you think that threat wasn't made out, or you think the other 2 are stronger and it doesn't really matter?
No, I think I have threat as well, but I was trying to establish the sufficiency under what would be the clearest and easiest to explain. Harassment I had to explain because the case law is very interesting on it, but our whole theory, why it's intimidating, is that he is implicitly threatening her with harm if she doesn't do what he wants to do. And, of course, that's the great jury question that the jury mistried on that, hung on this. How do you read this letter? Does he intend it as a threat, or does he intend everything to be literally what they are?
Sympathy.
And that's the question. That's what the jury had to decide and what it couldn't decide. And it's a triable question, no doubt. As far as our interpretation, there's a lot in here. Muggings, the only muggings that he thinks are worth talking about that his mother has undergone are things that happened near the judge's house, near her courthouse. He keeps talking about, even at the end, which my brother says is exculpatory, he mentions these rape, kidnapping charges in his long criminal record. He doesn't say rape, kidnapping. He says horrendous charges in September '88. That's the ones he's talking about, the ones that involved his ex-wife, who he lists in the letter.
I don't think that even Mr. Campbell would disagree that Mr. Hrycenko's sense of judgment may leave something to be desired with respect to actions that he takes. So, but yeah, I mean that's a different question whether it warrants any one of these 3. But your position basically is, I don't need to go there, but I think there's plenty of evidence for all 3 of those.
Yes, Your Honor, but I certainly don't think I need to have sufficient evidence in all 3, as long as I have one of them. If there are no further questions,
So what you're suggesting is that the 4 jurors could say, well, this we think is intimidation, 4 saying, well, this is a threat in my view, and 4 saying this is harassment, and that doesn't matter.
I think that's true. There was no request for a specific unanimity instruction in this case, but I do think that's the case. Just like I keep going back to Brian Smith because I argued it in front of Your Honors in September, so I remember it pretty well. But just the jurors didn't have to agree when the defendant had the knowledge of occupation, whether at the time of entry or at the time of remaining, the same logic would apply. They're just not different enough to set up different crimes that would have to be unanimous or have sufficient evidence of everything under the Plunkett sense.
Okay.
Thank you.
Thank you, Your Honors.